Good afternoon, dear colleagues, ladies and gentlemen. Please take your seats. We now start the first academic panel at CPDP in a series of 4. And we have 3 speakers for today. I will be chairing and moderating the session. I'm Szekely from Hungary. I'm a social informatist, so to say. My research is focused on information autonomy, openness, secrecy, memory and forgetting, and archivistics, and related subjects. But I will not talk too much. We have microphones here, but only for the recordings. Can you hear us well? At least my voice, okay. So please try to be close to the microphones, even if there's no amplification, and people can hear us very well. So first, I would like to briefly introduce our speakers, one after the other, and I will also ask them to say a few words before they start presenting their papers, in order to break the ice. You know, we would like to hear the voice first, and then they will have, let's say, 15 minutes for the presentations. We'll have a short questions and answers session after each presentation, then the next presentation, and so on. And at the end, hopefully, we will spare some time for a general questions and answers session. So the audience will be encouraged to spare questions to the last Q&A session. Take your seats, please. So Primavera de Filippi is sitting next to me. According to the information which I received from the speakers, she's a permanent researcher at CNRS, that's the National Center of Scientific Research in France, and the Université Paris number 2 or in French, yeah. She's a faculty associate at the Berkman Center for Internet and Society at Harvard, where she is investigating the concept of governance by design as it relates to distributed online architecture such as Bitcoin, Ethereum, and so on. So my first question to you, what do you mean governance by design, or how would you place it in the cloud of expressions and notions like code is law, data, big data is law, algorithmic regulation, actuarial society, and so in this cloud, how would you put governance by design?
The reason I say governance by design as opposed to code is law is actually because I want to distinguish between those. Code is law is kind of this, to some extent, like top-down approach, in the sense that you design the technology and the technology will dictate what people can or cannot do online. The idea with governance by design is to actually kind of flip the picture, and it's about how we can actually use technology in order to help govern ourselves. So it's no longer the engineers designing a technology which will, basically stipulate exactly what will happen, but it's about how communities or how organizations, platforms can actually try and figure out how you can encode governance rules within the technology so that then people can actually use that technology on top of that.
Kind of self-governance.
It's more of a self-governance approach, yeah.
Like the new identity management systems, which are kind of user-centric identity management systems. So that's also user or subject-centric.
Yeah, it's giving the technology as a tool for people to then use it for their own purpose.
Great. Gianclaudio Malgieri is a research assistant at Leader Lab, that will be my question, at the Institute of Sant'Anna School of Advanced Studies in Pisa, Italy, and his research area is law and technology. His main research field is the intersection between intellectual property and privacy, and his paper is about this subject. But what does this kind of mysteriously sounding Leader Lab is doing?
It's an interdisciplinary lab of law and technology and law and medical science, and so there are several departments, and mine is about health, technology, and law as related. So there are lawyers, but also medical scientists and engineering. So it's It's just a particular legal laboratory.
Okay, so you have a legal background.
Yeah.
Okay. Then Christoph Bier is a researcher at Fraunhofer. Would you also tell us what IOSB means in Karlsruhe, Germany, in the field of group identity protection and management? And he's a PhD student at the Faculty of Computer Science at the Technical University of Munich. His research interests include data provenance tracking, that will be my second question, distributed usage control, as well as technical and international data protection, in particular the data subjects' rights. So what is IOSB? Just to let us know. And what do you mean data provenance tracking? Okay. Maybe it will be clear from your paper.
So IOSB is the Institute of Optronics System Technologies and Image Exploitation. So we have 3 different areas of research in our institute, and the data protection part of research is part of the system technologies branch of our institute. And data provenance tracking is on how to know what is the lineage, the provenance of data. So where does it come from, who created it, where does it flow to, and what happens with the data? How does data interact with each other?
Okay, there's a fourth, not the speaker, but fourth author in this panel. That's Simon Kömpf, who is the co-author of the paper. Christoph Bier will present to us, but Simon is not with us. But he graduated with a BA in computer science at Karlsruhe. But not so long ago, it was in 2015. As part of his thesis, he conducted research on the data subject right at Fraunhofer. Last question, how did you split the work, or how did you share the task? Because you will represent the two of you.
Yes, well, I was his supervisor during his thesis.
It's easy.
So it's, I have to admit, it was my idea. He did most of the technical job, and I wrote most of the paper. So that's how we split up. Yeah.
Okay, thank you very much. Now, Primavera, please.
Thank you.
Your presentation.
So this presentation is it's about, like, we talk a lot today about all the problems of big data and how they affect privacy. And the underlying hypothesis is that the main problem is actually cultural, in the sense that most individuals actually want to benefit from the customization and the personalization that comes out of the big data analytics. And even though there is like a lot of discussion on whether or not specific online operators are actually entitled to use data in a particular way, the ultimate problem is that there is eventually always consent that comes. So then we can talk about whether it is informed consent, whether it is explicit consent, but in the end, if there is a service that the user wants to benefit from, they will click that button. And so the question is, what is the consequence of this? So perhaps we need to start thinking like beyond just data protection and actually look at the more fundamental issue of privacy and autonomy. But also, I think an important problem is that we need to figure out actual solution that would enable people to still benefit from the big data analytics, etc., and the personalization in a way that is actually consistent with their privacy. And only then we will actually be able, I think, to resolve this problem. So, doesn't work.
If it doesn't work, then please. Can you move it, or again? May I try it? Yes, now it works.
Okay, which one? Okay, so very rapidly, just a very short overview of how the internet, which started as this decentralized architecture based on the end-to-end principle, over time becomes more and more concentrated, and basically today we have those big, large operators that control pretty much most of the communication and that store most of the data. And this is in particular due to the advent of cloud computing, which obviously comes with very important benefits to the user, which is most importantly the fact that people can now access their data constantly at any time from anywhere, independently of the device that they are connecting to. So the cost of centralizing the data and centralizing the service, providing an online web application, is obviously reflected by a very tangible consumer benefit. So obviously this creates a series of legal issues, whether it is because we have this single point of control that govern all the data, that store all the data, that process the data, but also more technically we have all the data that is stored on one location, and it is just as soon as one managed to actually breach into this system, then they get access to all the data at once. There is also the problem of dependency, in the sense that we now have like devices that are becoming more and more weak and tethered devices, so that without the connectivity, actually, we can hardly do anything with our computers. We always need to be constantly connected to the internet in order to actually not only use our data, but even use like software and etc. So the user becomes more and more dependent, and this obviously give more control to the platform, because the platform can basically track every single action. It's not just the content that is uploaded, but they can track the movement of the mouse, they can track how many people at what time they are connecting to what, etc. So the amount of data that can be collected is obviously much greater in the context of cloud computing application. There is also the problem of walled garden and consumer locked-in. So because all the data is uploaded on a particular service, then it becomes more difficult for users to actually decide eventually to leave the service, because the cost is much higher, because they will also lose all their data. And then the problem of the lack of interoperability and data portability. And then, of course, there is also the issue with filtering and censorship. So because the platform is governing everything, then they also decide what can be visible and what should be exposed to the people and what not. So the users slowly start losing more and more of their ability to control the tools that they are using and to control the type of communication that they are entitled to have.
Excuse me, is it possible to use the microphone? It's difficult to hear them.
I think they don't amplify. I can just speak faster, louder. So and then the main problem, which is the one that I want to address here, is the question of privacy. So the data collection is obviously one problem, but it's also the problem of data sovereignty. So it becomes harder for people that don't even know which data is being collected about them to actually go and control that the data is actually accurate. And then to oppose the use of the information, because the use of the information is actually done internally within that platform. And then comes the big data. So it's not just about data collection, but it's actually about aggregating different data sets together in order to actually create more valuable personalized service and customization. And so by using statistical analysis, the greater, the larger is the data set, then the more information can actually be provided, and therefore the better the service that is provided to the users will be.
Can you scroll up more so that one slide fit in on one screen?
There is a little slide problem. I don't know how to fix it.
Oh yes.
Anyway.
It will be worse.
Yeah, it's gonna get worse and worse, but eventually we can do it, the bullet fix. So and then there is the question of when we start using data analytics and data mining, not only in order to aggregate and use statistical analysis, but when we actually start generating new information which are inferred from the aggregation of the data. So this becomes
could you try to use this? Where is the? Yes, it's a bit better. Okay.
Okay. So in this case, the online operator, they can actually infer new information which could actually qualify as personal data to the extent that it actually serves to identify that it qualifies as personally identifiable information. And the question here is that even if people have actually provided consent for the collection and the processing of their personal data that they actually explicitly given, then can we actually infer the consent for the inferred data that is actually issued from the aggregation of this information?
You can use it, yes. A new page, and you can correct it.
And indeed, the main problem today is that it's the information that is collected about us does not only come from our own behavior and on the explicit information that we provide, but it also comes from what other people are actually saying about us and about how other people are actually interacting with our own online persona. So the privacy problem are obviously quite important, but it seems that, at least for many users in practice, the benefits that they can get oftentimes outweigh the cost of privacy, and this is probably why everyone is using those cloud computing platforms. So the question becomes, the two questions that I want to address here is one, what is the hidden cost? So most people that consent to actually providing this personal data and processing of personal data, they might not actually be aware completely of what is the cost of this consent. And the second one is like, even assuming that this consent is actually given explicitly and well informed, then is it possible to provide a specific alternative that will actually not require the user to consent because they want those personalized service? So for the first point, the question is, what is the ethical and moral responsibility of online operator to actually intervene and to disclose data to specific authority? So in terms of data disclosure and data direct intervention. So we know that there are certain laws that specify that there are certain conditions in which operators are obliged to actually provide information to governmental authority. Now the question is, what about voluntary disclosure? So can online operators, do they have the duty or do they have the right to actually disclose information on their own behalf? And these already, so we know that, for instance, the big data analytics can actually enable to identify specific features or specific characteristic of the user. So for instance, we have Netflix that supposedly is able to identify user with attention disorders. Or we have Facebook that is able to detect when someone has a postpartum depression, etc. So in this case, then do the online operator actually are entitled, or do they even have the right to communicate this information, for instance, to a doctor or to some person that could actually help the user? And if we look at the 1995 directive, then Article 7 actually specifies that there is a possibility that online operator can actually disclose information if this is necessary to protect the vital interest of the user that they collect the data for. So this is a question that it's questionable, but potentially there is actually a possibility for the online operator to disclose this data. And then it becomes more problematic, of course, when it's not just about helping the user, but it's about identifying users which have like violent behavior or maybe criminal tendencies, which is just some kind of profiling. So it's more of a prediction or it's a potential assessment, but the user has not done anything yet. And then can this information, which is just inferred or like deduced data, can it be used in order to provide, in order to be communicated to the authorities so that the person will actually be under increased surveillance because this is a person that is potentially risky individual? Or on the other hand, can this information, which is actually not real information, but inferred information, can be used in court in order to actually incriminate a person? And then, so that's about the data disclosure. And then in terms of direct intervention, then the question is like, what can the online operator actually do with those data? So beyond the problem of disclosure, they can actually use the data internally into their own system in order to, of course, provide a more personalized system. But what is the implication of this? So most importantly, there is the problem of like the filter bubble. So as we provide a more and more customized and personalized service, there is the risk that users actually end up always being exposed to the exact same content because they have been profiled as someone that would like this content, and then they just start consuming always the same content, and therefore they get even strongly more profiled as someone that wants this content. So it creates a bubble in which people are stuck into, and they do not have the opportunity anymore to actually see alternative types of contents. And then we have like even more critical situations. So for instance, the Facebook experiment, which decided to manipulate the newsfeed in order to see what kind of impact it will have on the mood of users, and basically to try to test the virality of information. There was another experiment with voting. So Facebook started displaying to a specific test group that their friends had actually gone to vote in order to see whether it will actually have an impact and motivate those people to go voting. And there was like for a decent statistical, meaningful number, which I forgot, actually people were reacting positively to this, which means that this can create obviously really dangerous consequence in the sense that Facebook can infer, for instance, what is the political party or the political approach of a particular individual, and then only display this information to the people of a particular party so that they can actually, to some extent, modify a result of an election. And then we have, of course, the problem of the black box society, which is that more and more people, we have no idea of what is actually regulating, or what is determining the interface, and what is stipulating what kind of content we will actually have to see, because everything goes into this black box, and oftentimes even the operators themselves, they don't really know anymore how the algorithm works, because it's based on like machine learning. So we just have data coming in and being processed by this box and coming out, and we cannot really assess whether this is based on reasonable grounds or whether this is completely biased for specific commercial interest and so on. So more and more we're moving into this data-driven society where the algorithms are getting more and more importance. We're even moving into this level in which data is actually being used in order to make policy decisions. So we have this concept of data-driven policies and data-driven regulation, which actually look at data as this kind of objective factor in order to calculate, on the one hand, in order to decide what kind of policy to make, and secondly, in order to benchmark those policies. But obviously the problem is that data is obviously biased in terms of how it is collected and how it is interpreted. So this can become really dangerous if we don't actually pay attention to what is the source of this data and how exactly what is the process in which the collection has been done, etc. And then, of course, even more forward is the problem of data-driven enforcement, which is not just about making policies according to data collection and inference, but it's actually about enforcing those policies. But oftentimes, when it is data-driven, it means that we will act because of prediction, and therefore we will act before something actually happens in order to prevent something bad from happening. So this creates this concept of preemption, which is changing basically the environment in which people are actually operating in, so that they will not be able to act in one way, or so that they will be encouraged to act in a different way. I think the most interesting example of this is the citizen score that is now being made in China, where the main Alibaba and the main search engine of China are now, according to big data analytics, they are coming up with a citizen score, which is determined according to internal algorithms, and then the government is actually using the citizen score in some way, as like in the US we have the credit score in order to decide whether someone should be given a loan into a bank. Now we actually, like in China, it's actually being deployed at the societal level, in which information that has been collected by private operator is actually determining how the government will actually deal with their citizen. So the main problem again is that we have data protection, we have privacy regulation, etc. But they are all limited by the fact that once there is consent, then the operator is now entitled to actually do anything with their data. And then we oftentimes need to remind ourselves that this is not just about data protection. This is really about autonomy and agency. And even though someone might actually consent to the processing of personal data, perhaps they should be informed about the fact that this consent is having much, much more impactful consequences when it comes to their ability to actually act, to their ability to see certain types of content, and so on. And so to conclude, then the question is, like, how can we actually stop this cycle in which user will continuously give consent because they actually want to enjoy the benefits of big data? And so I would just like to propose one possible solution, which is based on blockchain technologies. And so Bitcoin is just the first instantiation, the first example of what blockchain technology can do. But now there is actually a lot of new applications that are emerging. And the idea of the blockchain is essentially disintermediation. So in the same way as Bitcoin has disintermediated the financial operator, then there are now new applications that are trying to disintermediate other kinds of operators. And so to some extent, it is actually possible to disintermediate also data processing and to potentially move away from this concept of black box society in which we have one operator that stores all the data and that is the ultimate dictator of what will happen to this data. And we can move into a system where there is a more personalized personal data management, where the user actually still benefit from the service because the data is actually online. So it is akin to the system of a cloud computing in which you can connect to it all the time, you can access it from everywhere and with any device, but it is not stored on one single server. It is stored in a decentralized network in a way that is encrypted so that no one can actually access the data. And so I will just present this project. Is a project that is now being developed at MIT. It's called Enigma. And the idea is to use the blockchain as a mechanism where people can upload their data and then they can assign specific tokens to people, and only the person that has the possession, that can prove the possession of that token, is entitled to actually query the decentralized platform. And the interesting thing is that it never requires access to the data itself, because no one needs to know, for instance, if a particular operator wants to know whether I'm older than 18, they don't really need to know what is my date of birth. They just need to know whether or not I am older than 18. And so in this way, that operator could actually query the platform and just ask, is Primavera older than 18? And then the network, in a distributed manner, is going to calculate the result and only give the outcome. And the user can then see at any moment what are the requests that are being made, and the person that made the request only gets the exact answer that they asked. And these can be modularized, so there can be different kinds of tokens for different levels of privacy that can be done. So I can choose, according to how much I trust the people that I'm interacting with, what kind of token to give so as to determine what kind of data they can use. And the interesting thing with this is that this enables not only for individual personal data management, but is also enabled to, for multiple people to actually create this kind of public licensing of data, so that big data can still be used and can still be used for all the great things such as personalization, customization, or analyzing, for instance, like healthcare situation with quantified self, etc. So all the benefits of big data can be preserved, but in a manner that is completely consistent with the privacy choice of the people. That's it.
Okay, thank you. Before giving the floor to the audience for quick questions, may I have some quick comments on this? And in the meantime, I would like to ask Gianclaudio, who will be the next speaker, to come here and start his presentation correctly. And also I will ask you to speak standing, because your voice is not so... You can stay here, but people can hear your voice better if you stand up, but it's up to you. If you have a strong voice, that's okay. I like this paper very much when I read the first time, partly because you use all my favorite quotations and references, from Filter Bubble to Lawrence Lessig and all the things. But there was one other reason which was not emphasized in your presentation now, and that's autonomy or agency or freedom of the individual. And I completely agree with this, and maybe later in the discussion you can develop a bit more that it's not the privacy what's the most important questions. I don't believe that privacy is dead, of course, but autonomy is even more important. So we can even rename CPDP to CADP. Computers, autonomy and data protection, because privacy is just a subset of this kind of autonomy we are losing. And even the title of your paper has user privacy and individual agents in the age of big data. So that's a very important element. I hope we'll have time to discuss it. And maybe if you allow me one more sentence, that autonomy is a broad concept. Information autonomy is a growing but still sub-concept or sub-field of this. But all these contribute, I'm sorry if I'm too philosophic, to such basic values like freedom. And we are not talking only about individual freedom. That's the most visibly infringed or limited, individual freedom in the age of big data. But also collaborative or social freedom. There's a philosopher and sociologist, a German, Axel Honneth, who has a third type of freedom. Not only positive freedom, you do what you want. Negative freedom, you are free from the influence of the state or Google or others, but a kind of societal freedom which can be realized only in interaction with others, without interference of friendship, law, democracy, are things like that. So all what you mentioned gave a nice overview of is the environment which is eroding all these values and all these possibilities. So there are many things to discuss here. So first, few maybe clarifying or short comments or provocative comments from the audience or questions to Primavera. If not, this point in moderation, then please reserve your questions to the proper questions and answer session. Okay, then Gianclaudio.
Thank you. Thank you, everyone. So I'm going to speak about the famous conflict between consumers and companies about the control and property entitlement, we can say, of personal data. But I would like to do it under a different light. I would like to speak about this conflict as a conflict between intellectual property rights of companies against personality rights of individuals. And as you can see in the image, these two cages are probably the two areas, privacy and intellectual property. They rarely communicate each other, but we will try to make them communicate in this debate. So the background are, of course, how we can face customer data, because personal data protection law are more and more based on proprietarian approach. And meanwhile, companies tend to protect their customer information, which is not just biographical information on raw data, but as Primavera said, a lot of customizing information, behavioral forecasts, life expectancy. So what we can call the gray area of personal data, because they are created by companies, even though starting from consumers' data. And intellectual property law tend to set a proprietary approach as well. So we have two intangible monopolies in conflict on the same good. And maybe it's not just a coincidence that two parallel reforms in the European Union have been proposed in these two fields. Apart from the famous General Data Protection Regulation, we have the first proposal of a directive on trade secrets. And this is not just a theoretical issue, but also a practical one. Because in 2011, there was the Facebook case involving Max Schrems, the most famous privacy activist in Europe. And he asked Facebook to access all his data, all data related to him. And Facebook answered that it could not disclose all data because Facebook would not disclose information which is trade secret. And it's permitted by law. And so we should see this area of intersection. My research questions here are this area of intersections and how the two legal frameworks, so privacy law and trade secret law, interact, how to balance this conflict, and if it's a real conflict. And maybe the last point is if this debate can contribute to the commodification of personal data debate, a different area, but I think quite similar. First of all, I would like to explain why I will not speak about databases, but just about trade secrets. Database as a sui generis right, according to Article 7 of the Directive 96/9. I think that in the age of data mining, Internet of Things, big data, we cannot consider database as the best intellectual property right for companies to protect their relationship with customers, etc. Because these data are not structured anymore. And personal data of customers are not units, but they are more and more an ecosystem, a form of knowledge more than just information. So we need a more fluid intellectual property right, like trade secret is. And also because databases are generally considered for partial disclosure, and it's not suitable in the competition world. So I would like to understand how wide is the area of intersection between trade secrets and personal data. And we can do applying the eligibility requirements of trade secrets regulated by Article 39 of trade-related aspects of intellectual property, the TRIPS agreement, and apply these eligibility requirements to customer personal data. We have three eligibility requirements. First one is actual secrecy of information. Second one is the economic value of information. And the third one are reasonable precautions to protect information. So, first of all, actual secrecy. Of course, most of personal data of customers are secret. And it's an interest both of companies and of individuals to keep those data secret. Even because in many national data protection law, there is a weaker form of protection to personal data made public. And in the world of big data, it's also easier, maybe, to keep this secrecy because that data are fragmented, separated, decontextualized. As regards economic value of information, this is a specific point because customer data are of great value. And as regards reasonable precautions to protect information, even this point is always fulfilled by personal data related to customers because it's a legal duty. Article 17 of European Directive and Article 30 on data protection regulation are state the duty to protect customer data processing by appropriate measures. So there's a great area of intersection. And who wins in this intersection? To understand who wins in this intersection, maybe we can analyze the balancing provisions. It's interesting to analyze recital 28 of the proposed directive on trade secrets, where it states that the fulfillment of rights and duties of trade secret law should not affect data protection law. But meanwhile, recital 41 of data protection directive states a similar thing, but opposite. So it states that the fulfillment of rights and duties of data protection law should not adversely affect trade secrets. So maybe these two rules are schizophrenic because they feel same and opposite things. But maybe it's just a non-prevalence rules. They just state that each discipline does not prevail on the other one. It's a non-a priori evaluation, but a case-by-case basis approach. Each time we have to see if that data can be disclosed or not, can be erased or not, according to trade secret interests or to privacy interests. But if we want a tap in this case-by-case approach, we can maybe have it by a literal interpretation of these provisions, because if we analyze those provisions, we can see that there is a preference, but not a prevalence, for data protection rights. This preference is understandable by the fact that the only data protection rights which can be restricted in order to protect trade secrets is right to access, and just in a proportionate and necessary manner. So maybe there's a wider protection of privacy than of intellectual property in this conflict. And so what I'm proposing is a model that I call decontextualized cooperation. And now I will explain you what is cooperation and what is decontextualization and why. Why cooperation? Because there are common interests to individuals and to companies on managing of data. And these common interests are secrecy, accuracy of data, integrity of data, reasonable precautions to protect data. And this is also clear with privacy by design, because there's a cooperation in protecting data. Also the user is central in this operation. And this is also consistent with the so-called prosumer law, a theory about the multi-stakeholder co-regulation in the internet governance, and also consistent with the theory, an American theory about shared privacy. And we have also an interesting point towards this cooperation in the General Data Protection Regulation, because at Article 24 we have the figure of joint controllers. And joint controllers means that users and companies can jointly control data. And this is the first time totally regulated by the data protection law. And this is very interesting for our discussion. And why the contextualization? Because there are conflicting interests. As I said before, there is a gray area. And this gray area is the intellectual output of companies about personal data. And so, in fact, for example, data access, data erasure, data portability are a problem in terms of intellectual property. And in terms of competition, let's think to data portability. It's a great challenge to competition law. And so, maybe only by decontextualizing all information by their economic context, and, for example, accessing just a decontextualized form of that information, we can solve it. Now I will explain it by some examples. An example of decontextualization is very, very similar to Enigma example that we saw before. It's the OpenPDA safe answer of Massachusetts Institute of Technology. So the consumer can decontextualize all its raw data to mobile apps. This is a software projected to help consumers to have all data, raw data related to him in his personal databases, in his personal devices. And the software just sends specific and safe answers to app. So, for example, the age or specific answers, but not pertinent answer, but not general raw data. And it's interesting that also there's a similar system in the relation between Facebook and Facebook-related apps. Maybe because Facebook wants to have the monopoly of raw data, but it's an interesting point. And just to finish another example, the cooperation. An example of cooperation is Google ad setting. Google allows us to know what he has understood of us, what he has planned, what he has forecasted about us, and we can interact with him. We can change, correct, integrate. The last example of cooperation are the smart grids. It's a point of the Obama administration, the so-called green point. So if we share data about our energy consumption, we have a remuneration, but just a saving, we can say. And so this is an interesting point about cooperation between different actors. And so just a last hint for further research is that personal data are a de facto property in EU. And trade secrets are considered quasi-property in the common law countries. So maybe we should give value to this idea of quasi-property. And this value is to understand what is quasi-property and to apply it to personal data. Quasi-property is a legal concept of common law countries, which was created to face to the unwillingness to commodify personality rights, and is very important the context in quasi-property, because it's not an extra erga omnes right, but it's just a contextual right, and we know how important it is in privacy, the context. And it's very much used in competition issues. So maybe the commodification of personal data should get this direction, but it's just a suggestion. Thank you.
I'm not sure everybody agrees on the propertization or the property nature of personal data and the commodification, but that's subject to debate. Direct questions to Gianclaudio.
I have a question on whether you have examples of case law involving, for example, what you mentioned at the beginning of your presentation on a data controller denying access and invoking trade secrets, or the opposite, or perhaps in Italy or even some national case, or not just European?
Luckily, there is no case law. It's just a private email that Max Schrems received, and he advertised it. And there is the ADPS recommendation, which just tell about this story. But there are no case law in this moment. But I think that when Trade Secret Directive will be enforced, we'll have some cases, I guess. I don't know now.
If I may add, I think there is some case law from Hungary, maybe about this, under an earlier provision of law, still in effect everywhere in Europe, that the prohibition of automated or fully automated decision making, which includes the right to learn the algorithm, so to say, the reason why certain decisions were made. And of course, companies will not be willing to give out the little specificities of the algorithm, because this is their trade secret. So there, as I remember, there are some cases we can share this. So, Christoph.
Okay.
controllers.
No, that's not.
Should just scroll.
That's better.
Maybe it's working.
Okay, great. Okay, welcome to the last presentation. My presentation is on corporate compliance with transparency requirements of data protection law. As I already mentioned in the introduction, one of my research topics is data provenance, so to know where data is coming from and flowing to and things like that. And one of the reasons why I'm interested in data provenance is transparency. Transparency is codified in the German Constitution as well as in the Charter of Fundamental Rights of the European Union. And one of the instruments of transparency is the right of access. And to provide all the necessary information for the right of access, we have to empower companies to gather the information in the first place, where they got the data from and where they transferred the data to. So after a moment, I thought about, well, is this research necessary? It would be necessary if companies wouldn't be able to comply with the right of access at the moment. So we decided to set up a study, a two-step quantitative and qualitative study to evaluate the state of practice of personal data processing, especially the right of access. We also evaluated the compliance with German law against unfair competition, because it was a side effect that we had the data to answer questions on this topic as well. The first step of our two-step quantitative qualitative study was, and I forgot to explain why it is a two-step study, is because we collected data at two times. In the first step was to generate a representative sample of companies and let them know artificially generated personal identifiable information or personal data. And we focus on email addresses because email addresses are more or less easy to track and generate, and they are used for various purposes, for B2C communication, especially for advertisement. And we set up a honeypot system to monitor the use and or misuse of personal identifiable information by tracking how the companies would use the email addresses, and if they would transfer the email addresses to other parties and they would use the email address, we could track that as well. Here you go. Okay. How did we find the representative sample of online data processing companies? We looked at WSET 2008, which is based on UNACE and UNISIC, a scheme to structure companies in different groups and sections. And we selected the sections with an online presence of more than 60%. And we tried to cover with our sample set small and medium-sized enterprises as well as large companies. So we selected companies from each division and groups, 17 groups altogether, and 612 companies in total. So we generated for all these companies artificial data sets of personal identifiable information, including the email address, of course, but also the postal address, date of birth, first name, last name, stuff like that. And then we took this artificial data set and registered the data at the different companies, one email address and data set per company, and altogether we registered 152 user accounts and 460 newsletters at different companies. We filled out all optional fields if they were available to increase the value of the data we provided. And at the same time, we set up a honeypot system. A honeypot system in general means a computer system or network which is closely monitored to see any violations of security requirements or stuff like that. For example, to collect viruses, swarms, and things like that. We set up a honeypot system for emails, which was just a server solely set up for the purpose to receive the email sent to the addresses we registered at the companies before. We monitored the inbox of this server for an evaluation period of 102 days. And the emails were automatically analyzed by a script to identify if the emails were sent from a domain which belonged to the company we registered the email addresses at, or from a third party. We categorized all the incoming data afterwards, also according to the requirements of the German law against unfair competition. The three requirements of the law against unfair competition we took into account were that the email advertisement must always be based on consent. So there must be an email asking if I really want to receive this newsletter. There must be a complete imprint, which includes address, website, phone number, and email address. And there must be a link which enables me to unsubscribe from an email newsletter. Out of our sample, 87 companies send us emails, and 87% of the companies, 535 altogether. And of these companies, 97% complied with the law against unfair competition for the emails after the first and the second email. The first and the second emails were in many cases not in compliance with the requirements because there were registration emails or welcome messages which did not include a full imprint, for example. So, but we wanted to further use the data, and our main interest was which companies actually transferred personal identifiable information to third parties, and if we asked them based on the right of access, would they answer properly? To our luck, I don't know how to say, well, we observed only 4 companies transferring personal identifiable information to others, which is a good thing on the one hand, but on the other hand, it was a bad thing for our study, as the sample for the second round was a bit small. So we decided to gather some more samples by selecting companies we as researchers had contact to in advance, like Amazon and stuff like that, with personal relationships with, and asked them, according to the right of access as well, to provide the information which they should provide us according to data protection law. So we had altogether 20 responses to analyze, and we requested all the information in the broad wording, which is allowed according to German data protection law, to not exclude any information by ourselves a priori. And we had altogether 12 legal requirements, which I outlined in the paper, but I did not include in my presentation due to time constraints. 4 more formal criteria and 8 content-wise criteria. And we checked how many companies did comply with these criteria. And and the numbers were actually pretty low for most of the content-wise criteria, while most companies replied in time and it was possible to contact them on the ways they contacted us and things like that. The information in detail, so which personal identifiable information was transferred to third parties, where is it actually stored, in which departments, for which purpose, things like that, was for most companies not provided to us. So to conclude, the situation is pretty good from our point of view. For the law against unfair competition, most companies comply with this law, but the situation is much worse with data protection law, especially the right of access, where only 3/4 of the companies complied with our basic requirements, and no company was able to fulfill the full set of requirements we described in our paper. I don't think that the main reason is that companies are not willing to, which might also be the case, but there's also a lack of technical functionality supporting companies in providing information they need to fulfill the right of access. Hence, it is, from my point of view, a good result of the whole study, as it gives value to the other research we do at Fraunhofer.
Thank you very much. I would be happy to receive such empirical research results in my own country, so that's not so bad at all. But it shows the difference between the empirical researches, one when we ask the companies what they do, and one the other one when we really try to measure what they are doing in practice. And sometimes the difference is quite big. Questions to Christoph, and also your own reserved questions to the other speakers. Please now ask these questions too, and comments.
I'm not sure if I understood correctly. Did you say that 4 companies transferred the data to others, or did you mean that there was 4 companies to which this data was transferred? And if you meant the former, how do you know who transferred?
We know who transferred because we registered each email address only at one company. So as we got the response to this single email address, we did know where it initially came from. And the number 4 is 4 companies who transferred personal identifiable information to 4 separate other companies. So it's the same numbers, 4 and 4. But it's only the number of transfer we can observe because they used the email address. We don't know if they transferred other personal identifiable information to other companies which never used the email addresses, so we could not track that.
Okay. And can I ask a follow-up question? So of those 4 companies, how much did they disclose to you after the follow-up?
5 more minutes
okay.
for the next session. Thank you.
2 companies did not answer at all. One company answered within 1 hour and told us they did not understand our request. And the 4th company answered and provided us information what they store about us and things like that. But they told us they never transferred personal identifiable information, and because the emails came from a source which is not of such high reputation, it might be the case that they got hacked or something like that.
Good answer.
Thank you. I have a question for Mademoiselle de Filippi, and it's more a sort of maybe a general question from my understanding. I'm sorry, by the way, I'm Thomas Eotvos from the European Free Trade Association, but I don't like to do presentations. My question was with respect to systems like Enigma and so on, and I mean, I'm really not an expert, so I'm trying to understand this, but I sort of have a problem, which is that I feel that sort of the big privacy debate at the moment, and I think that was also the theme here of calling it, agency, agency in a world of big data and so on. But one of the problems that we have is that we as individuals were confronted to a system, to your black box system, where we have either we have Big Brother and government that is watching us and collecting all of our data indiscriminately and so on, or we have corporate awful monsters like Google and Facebook that are collecting all of it and that are reselling it. So basically, either we're being overly surveillanced or we're being basically mined, as by companies. And my problem a little bit is that I have the impression that a solution like a system like Enigma, for example, that works well to sort of address the how do we build a better machine, a machine that is more respectful of our agency and our autonomy and our possibility to take decisions and address our concerns. But it does very little to tell me how do I actually fight the machine that already exists. And then my question is, I mean, how does that, do you see a practical application for something like Enigma? In particular, well, and I just mean that in the sense that for me I have the impression that the technical solutions that we are being offered now have to be solutions that we can implement unilaterally. We need to be able to sort of deprive whoever it is that wants to mine or collect our data of doing so, and we need to be able to do it ourselves. Because going to Facebook or Google and telling them change your system so that it's compatible with this one that is very respectful might not happen just tomorrow.
Well, so first of all, Enigma is not trying to fight Facebook or anything. It's actually trying to provide an alternative. I think, I guess there's 2 important points to answer your question. One is that, to some extent, it's like you need first, in order, like there is the Facebook and Google and whatever that anyhow they do what they can do. The problem is that we need, like, until there is an actual alternative to the service, then it's going to be really hard to even try to fight those, right? So we can use the law, but again, the law is limited by the consent. So if I want to benefit from a customized service, I will consent nonetheless. Now the problem is that perhaps if there is an alternative service that actually provides similar personalization and customization, then I might actually start thinking twice before I consent to Google, because I know that I can actually have, maybe not as good as Google, but I can have an alternative service. So that's one point. The second point I think is actually even more interesting, is the fact that, and it raises really interesting ethical questions as well. Today we're actually we're paying with data in order to have a free service, right? If we want to have privacy, we have to pay. So in some way, we're actually paying with the data. And in a system like Enigma, you can actually make a business model by selling your data. Now the question is it okay to sell your data? Well, actually, I would argue that we're already doing it, so it doesn't change much. But if you actually want to promote adoption of a service, then I completely agree with you. Privacy is not the right argument. Like, people will not shift to a new service just because it's privacy compliant, especially if the service is lower quality. So the first step is to make two services of the same quality, but even then, it's probably difficult to make them shift, mostly because of network effect. But when you actually incorporate the business model into it, then you actually have a tangible incentive for people to shift. And the Enigma system is such that we can actually monetize, because I can make certain data freely available for the big data analytics, but then I can, if you want extra additional data from me, then you have to actually purchase that token. So you can make a microtransaction based system where every transaction or every query on my data is actually remunerated. And I think at this point, when we have on the one hand services that are able to provide customization without holding the data, and we also introduce like an economic incentive on top of this, perhaps we can start thinking about how to fight the big machines.
We have a last short question and a short answer, because we are running out of time. Please ask a question. Was it you?
Well, me?
Yes.
We should have two questions. I don't know if it's possible or not. Well,
choose one and try to keep short.
Okay, a short one. So then, it'd be for Filippi. Just to mention that this position of dependence of the consumer to the platform. And then I was wondering whether you also analyze this problem from a competition law perspective, because I mean, thing that comes to my mind when you mentioned that is like market power, and well, it can like entail competition law problems. So that's my question.
Yeah, I mean, so all the initial problems that I mentioned, I mean, the consumer locked in, the data portability, the privacy itself, those are all like addressed by regulation. So whether it's privacy, competition law, etc. My argument is that regulation is only looking at the top of the iceberg, which is the impact on competition, which is the impact on privacy, etc. And we actually do not properly account for the bottom of the iceberg, which is individual agency and autonomy. And at the same way in which we actually, so the right of privacy is like this broad concept that cover like a very large set of actions. Of field, and then we have data protection, which is one particular part of privacy, which has actually been really well codified, so that it's now really easy to know whether data protection has been infringed, right? But privacy is much larger than data protection. So what I think is that, and then again, you have like competition law, and you have all those kind of vertical fields, but I think that we need to actually look in a more horizontal way and deep way of where it is affecting economy.
Yeah, I ask you to finish the last question.
Okay.
And I will argue that we actually need, in the same way as we have like data protection as a instance of privacy, we might need to think about how we can formalize autonomy or individual agency into an actual specifically designed legal framework in which we can easily say, is it infringing or not? Because right now it's really fuzzy.
Okay, thank you for your participation. Thank you for the speakers. And thank you for your questions.